Get it? Power.
This is Tyler at LPR. Hope everybody's doing good. We're going to talk about a few things. I'm going to give you an update on how my week was and why we didn't do a show. Coming up.
Things are going to start happening to me now.
I think Tyler is amazing.
And I'm a fan of this show. I've watched several episodes.
Thank you, Tyler. Thank you, Tyler. You stink, Tyler.
Never promise Crazy a baby.
Oh, I like that. That's a cool idea.
Are either of you homosexuals?
I go both ways. What do you think?
You mean like flaming or?
No, we're not homosexual, but we are willing to learn.
But I do wonder for others, in other cases, whether libertarianism today is just an excuse for many on the right to act selfishly.
Look at me. And then some fat asses in Washington started having opinions. The Olympic Committee started having opinions. You bitch, I know you. You started writing your opinions.
And it just makes me wonder, you're dead, bitch. You know, like, why are you doing this to this poor guy?
I don't care. I'm a libertarian. What I'm getting is,
Did you vote for Joe Jorgensen or Trump?
Who?
Joe Jorgensen. That was the perfect answer. Thank you.
I'm here. Is anybody joining us? Late notice. I got new little intro stuff. I got hooked on someone. If you may have heard of him. If you know who this is, let me know. Tyler Yonke, LPR. We usually do a show on Wednesdays, and it's Monday. And anybody going to come in? I don't know. But here's what we're going to do. We're going to just do a little chit-chat, a little talk about what's been going on. I want to talk to you about my last week at work. And maybe give you some stuff. We'll give a few minutes here. Let everyone kind of I know we're out to the platform, so come on in, people. Typically doing a show on Fridays. This is our special Monday edition. And okay, so no one's gonna be in here. Maybe you'll watch on the restream. That's fine. Last week I had a pretty big trial. I'm not going to tell you about the issues in the case. It's not fair to confidential shit. Attorney-client relationship. It's just not appropriate. I'm going to kind of give you what it was about. But I thought what I wanted to tell you was mostly the craziness with opposing counsel. This was, okay, here we got a few people coming in here. Okay. I didn't give anybody notice. I just said to my wife a little bit ago, I go, do you mind if I just do a show? And she goes, oh yeah, sure, great. And I was like, what is that? Did you mean to say that? But we got JC in here, Hubbleson, and I hope you guys enjoyed the Super Bowl. Here was my thought on the Super Bowl. I'm not a fan of either team. I wanted them both to die. I mean, really? Yeah, kind of. Right, I like the best scenario was it 2016 Super Bowls in Santa Clara, San Francisco, and that new stadium, but the power went out in the whole town, and so it during the Super Bowl, and it like caused a big 20-30 minute break. I was like, can something like that happen, but maybe more catastrophic? Hurricane Katrina in Louisiana, people down there, and anyway, something where neither team wins. That's what we are looking for. That's what it was. Anyway, I hope you guys are doing good. So here is what I thought I would just tell you. So I had this big trial. Now, typically I don't represent friends and stuff. It's just not the best. But I not necessarily wasn't friends with this guy, but he came to me from friends. So it's just like family, friends. Hey, this guy needs help. So I dug in, and it was a restraining order issue, which had implications with child custody and all kinds of stuff. And the allegations were pretty salacious. And I'm not going to go into what those were, but it was a 2-day trial. And I thought we had, because there were, okay, so as an example, I had little mini trial this morning. It was like literally 30, 40 minutes. It was a restraining order, and that one, it was very clear that there had been problems. There had been harassment, okay? And I was on the petitioner side, so we had filed this. The question there wasn't so much, did the guy do it? Because it was obvious that it had happened. It was more along the lines of, is this going to rise to the level of disturbing your peace, which, was this actual harassment? The one I had on the 2-day trial, it was not one of those. It was, did he even do these kind of things? There were salacious accusations. There was child abuse stuff there, all kinds of stuff. So we have this trial. She has 2 attorneys. They're kind of working together. They're in the same office, I guess. I don't know. It was kind of a weird situation there. And the main attorney, he was off. Then he was back on the case. So he was the main attorney for the trial. The other guy was a little bit newer. But that guy was very cocky, and we had some situations earlier where I kind of was calling his bluff on some things, and he thought when I was calling his bluff that I was saying he was a liar. So he had literally hung up on me at one point in the phone call. And I'm remembering now that during that time, he kind of said something like, I don't need to fucking listen to you. I'm driving a Tesla. And I'm like, what? What does that have to do with anything? So it was a little humorous there. Now we go into, and I'd given him an offer to try to settle this whole thing. So we go in and they set us out for a trial, and it was in front of a retired judge that had come back, and I know him. He does great work. So I was like, really already, okay, we're going to get a good judge for this. And now the prep for this is a lot. Okay. It's a lot of work the week before you have to have 4 binders. You have a binder of all your exhibits. You have exhibits for yourself. You have them for the other party. You have a exhibit binder for the judge, and then you have an exhibit binder for the witness stand. So 4 binders takes a lot of work. My wife came in, really helped because I totally trust her, and she's super good with this stuff. She took a day off work and just did a bunch of this stuff, and it was fantastic. So I was smile and be happy. Welcome. Thanks for saying peace. So it was good. I was really well prepared. I'd done a pre-trial brief because you could go in there, and these restraining orders. It's a little bit less like some civil stuff. There's, you have to have exhibits presented, weeks before. I did a witness list before, but it's a little bit more like the day of type of things here. So we go in there, we get it at court done, and now opposing counsel had sent me their exhibits the Friday before, but not the Thursday, because this was a Thursday-Friday trial. So he didn't send it on Thursday, so he hadn't, a week before, even though there's no thing, but he sent it to me on Friday, and I didn't send him my exhibits, copy of them, until the day before. But you're not even required to. You can do it the day of. So I get in there, he set us out, and we go into the courtroom, to the trial court. So you go into one main courtroom. There's all the cases that are set for that day, and then the presiding judge sends you out to different departments of who's going to take your case. So we didn't even know the judge that's going to do it. So you get sent out there. Opposing counsel's already there at the table, and I come in. I'm talking to my client, and we come in. And they usually want you to try to meet and confer and see if you can work some things out beforehand. So I put thinking I'm giving him the binders, and he's like, "Oh, we're gonna do a motion in limine for these exhibits. They weren't properly disclosed." And I'm like, "Well, one, I go to him. I go, well, one, there's no disclosure requirement, and 2, your motion in limine were supposed to be done the week before, so you're already out on that." And he's like, "We'll do it orally." And I'm like, okay, whatever. I don't know what you're planning to do, that you think that this somehow is my first time. Now, this guy's a younger guy, and he's like I said, kind of a cocky attorney type of thing. So then we're like, you want to go meet and talk? So we go in there, and he's just like, look, we're going to win this case. We're going to easily win this case. I'm like, oh, okay. We're going to easy. And so he tries to make this deal, and I'm just like, he does give us an offer. Finally, he kind of works his way off, and he does give an offer that my client turned down. But, with that, what I'm doing with my client is like, what are the likelihood? Now, this is a domestic violence restraining order. The level, it's a preponderance of the evidence standard, which is, I've talked about this before, but it's just barely over 50% likely that it happened. Okay. A balancing test type of thing. So, was this the case? So the standard's really easy, and it could go anywhere. The type of abuse can be anything from like, the beating the crap out of your, I just noticed there's a cord down here, beating the crap out of your wife, to disturbing her peace. Now there's a new aspect in California for domestic violence, and it's called coercive control. Now, just the words of it, you're already like rolling your eyes. I am too. And the idea there is that you have so much control over this party that it's a controlling, and it's basically abuse. Now, I could look up the code here, and I don't think I'm going to, but there's specifics with this. So it sounds easy, and it kind of is, but it's like controlling their finances to the way that they're not able to have any kind of autonomy with themselves. You don't let them out with your friends or with friends and family. One other aspect is specific there about sexual intercourse to have it's like basically impregnating someone without their, it's not rape, but it's something along the line, which didn't come into it. There was a few things. So it is somewhat specific. Okay. Now, in this conversation with this attorney, at one point I'm just like, hey, I gave you an offer that I think is pretty good. And he's like, not a chance. That's not going to be up. And basically what mine is we just kind of have a mutual stay away order. It's not enforceable through the courts, except for like with a contempt you'd have to come back into. And he's like, no, she wants to be able to call the cops and have them arrested right away. And I'm like, okay, so that's not going to work. But anyway, he's pushing some stuff. And at one point I said to him, I go, are you going to trial for your ego, or are you going to trial for your client? And he responds, this is all a great setup. Right? He responds with, of course I've got an ego. And he starts going off about, I make 8 figures. I've got a private plane. It did it. And I'm like, oh, okay. But I pushed back on this person. Now, it reminded me of, and by the way, I'll say this, through the trial, very professional. We got along. It was, I actually enjoyed the trial with him. He pushed me. I think I pushed him, and I think it was cordial. I actually enjoyed the trial with him. It was a lot of stress and whatnot, but he wasn't a dick at all. It was just kind of a curious part with this. And he's a little younger, and he's got a pretty big office staff. Matter of fact, the final day, and we'll get to that part because I do want to walk through this thing. So we couldn't make a deal. We go in there, the judge is like, let's go. So we're ready to go with this thing. And did he make any of those motions about my exhibits? No, because that wasn't legit. He had an expert. He had this guy who was a former attorney, a psychologist. His resume was bigger than this report did. Now he had given me all the exhibits the day, 6 days prior, but he hadn't given me this guy's report. So at the time I'm like, did he interview? What's he going to come and testify? He's going to tell us about the code, for coercive control. Like, I don't know that. What's he going to do? And he's like, no, he actually interviewed her. And I'm like, oh, why didn't I get this report? So he sends it to me. So we're trying to figure out, it's their case. So they put it on, and this judge is like, 2 days, you get the first day, she gets the second day. And my client said he, and I'm the girl now in this scenario, Tyler. We get the follow up, and you're gonna cut to it, and I'm gonna do. I have this is what the judge is saying. He goes, I am the gatekeeper for evidence coming in. 352 in California about, is this even the probative value? Is it worth it to even have it? So as an example, you're gonna start having character witnesses, which I'm not a fan of, especially for a situation like this. And I did line different people up that can come and talk about some things, but character evidence is just, at some point they're like, no, we're not going to keep having testimony about this kind of stuff. And if we're up against it, I'm not even going to need it. So anyway, the expert's not ready to go that first day. And I'm like, I was objecting to this guy already. Okay. So we start out with his client testifying. Now my client, like I said, I'm not going to get into all the details here, but what he had done, and this was fascinating. So she's testifying up until noon. She testifies the whole first day and even into the second day. So she's, and let me just say this, because this is somewhat interesting. If you guys are at all interested in stuff, how trials go, you have, and there's different techniques, or I guess there's rules, you would say, for direct examination and cross-examination, okay? Or redirect even. So if I call, or a hostile witness, the best part about someone's a hostile witness, they're not really, someone on your side, is you get to then have leading questions. Okay, so you can have leading questions on cross, but on direct, you can't have leading questions. The problem is, it's like, I'm gonna call her as a witness as well. He's gonna call my client as a witness. And so for efficiency, just go forward with, kind of direct, and actually he's got to do direct. But when I did my cross, I was doing some cross, I was kind of doing some direct, and there is beyond the scope type of a situation, which is anything they asked on their direct you're only able to bring those kind of questions unless you, quote unquote, open the door, as they say, to a topic that wasn't actually addressed. So with that in mind, I could, on my cross-examination, I could do my cross and within that scope, but I could also deviate a bit because we're just trying to save time. So everyone's on the understanding. And like I said, opposing counsel, professional the whole time. It was an interesting thing up front to say those kind of things behind closed doors, but it reminded me of when I was, I used to work in the finance world. Okay. So I was, did trade, first of all, graduate college, engineering degree. I get into a grad school in Colorado. I did it for a little bit. I did not finish. I then go to, well, I did a year of it. Was going for my master's, and I just quit the last item semester left. And I said, fuck this. And I went and raced my bike. Then we moved out to California, and I wasn't working. And so I got a job with a finance company, and I was working in their trading department, doing trade dispute stuff, and absolutely loved it. But I'd have to call New York a lot to talk to these traders to get, trades adjusted or figure out, hey, with the market maker, what's the situation here? And these guys were abrupt, they were rude, and you just have to push back. And as soon as you're doing that and you show, you can, by knowing what you're fucking talking about, they suddenly had respect. And I don't know if that's what happened with this attorney, where I pushed back and he was trying to do this thing like I'm going to object and therefore you're going to just, acquiesce or something. But, we had a respect after this initial thing. Now, I also told him, I said, look, I'm just jibing you too. I'm talking about your ego. I do have okay, whatever. So we're getting there. Okay. So first day, I had given my exhibits the day before. I had also given an exhibit binder in the morning. So they had two attorneys, they had her at lunch, they can start going through all these. What are they going to present? Because you can see from the binder, and I have a list, you have a front page of, theirs are, since they're the petitioner, at least in California, their numbers 1 through whatever, and mine are letters A through Z. So with that in mind, they can look there. I have a list of what all the exhibits are. I have them, lettered, and they can go in there and look at them. My client had saved up for the month kind of in question of this abuse stuff. It was June and July. He had all his text messages with her. Very important. With those text messages, I had him print them out, screenshot them for me, starting and I had actually exhibits A, B, C, and D of these texts, kind of split them up. But I always had a continuity. So you can see the date, and then there's a text, and text 2, you can see it still overlap from text 1. So there's always, here we go, all the way through. So you can have all these texts. There's not going to even be a question. And hers, she had like a snippet text, and, anyway, so she's testifying and she's, talking about her stuff. And then I start to cross-examine for the first day. And then we took a break and we went home. Okay. What was amazing though, were some of the statements she's making, that day about her testimony. And I'm like, I have text messages that just absolutely refute these issues. It's blowing my mind. And so I went home after the first night and I took all her testimony. I had, I'd taken notes through here because I got to cross-examine. And I'd made 3 things. I did a timeline of her testimony. I did a timeline of her petition, because to get this before the court in the first place, you've got to file a petition. And it's, her declaration of all these incidences of abuse. So I did a timeline of what she testified to, because she had days and everything was kind of wrong. Okay, but she was very sure about these. And then I did a timeline next to it of everything she had said with those dates in her filing, which was just days after these incidences. So that should be the most, right up there. The problem is when she was talking about it then, and then I did a third timeline, which was all the text messages that we had. So I had the true timeline from the text messages, and I had the testimony. And then I went back the next day and I just finished my cross, and I just had these things pinpointed with exhibits. And I'm like, this date, boom, you said this yesterday. Is that correct? Yes. In your petition, you said that. And now let's look at the text messages. And I just went bang, bam, bam. All 3 just walked her way through this stuff. Obliterated. I felt a pretty good job. My client was exceptional on the stand. And the reason I felt that he was exceptional, and the judge cited it in a decision, spoiler, we won, was because I tell him this, and it's the thing that bothers me the most about testimony. whether it's stuff I see every day or stuff you see in on TV or in court TV or you watch channels with law stuff going on, is testifying to an incident that's really, it's not material to the case, or it's semi-material. And what I mean by that is it at issue? Is it peripheral? And you're doing it in a way that's always in your favor. If the truth is out there, right? And if you messed up, it's perfectly fine. Matter of fact, I encourage you to admit that you messed up, or to whatever that accusation, that's the truth. Okay. But you're truthful, because it makes then the stuff that you're denying more impactful, because you can see that. Anyway, my client did that. He owned up on something, and it was, I'll just say it was, there's a form of contesting abuse. And he's like, well, I discipline my kids, but it's not hitting them. It's discipline, which is allowed in California, corporal punishment. And anyway, so there was corroborated evidence that helped along with that. So as and by the way, the expert comes out there, and then there's a lot of I had one. Let me just tell you. So if you have a text message, okay, it's a text message between my client and the other client. That's going to get admitted, because while it's hearsay, it's the words of a party opponent. So perfectly fine. They can also testify to it and have to lay groundwork to get these documents in. Perfectly fine. Now, if you have text messages between, opposing party and her friends, which they were trying to get in, I objected to those on hearsay, because they are. And the judge is like, yeah, you're going to have those parties come and testify. That's one thing, because then your confrontation clause, even though that's, it's criminal, you do have a right to contest. So it's hearsay, right? So it's hearsay. And if you want to know what the definition of hearsay is, hang on. It's an out-of-court statement made by a party, used for the truth of the matter asserted, okay? So now there's exceptions to this that you have in California, all kinds. There's federal exceptions, but we're in California, so there's exceptions to those. Sometimes the opposing party is wanting to get things in. We're not using it for the truth. It's your state of mind. Well, in some cases it was right. In some cases it was just, an attempt. But they had this one text, okay? And I had spoken to the actual person that had sent this text, and it was used, she was going to use it to testimony that it was harassing. Now, there's all kinds of stuff with this person that there's privilege, but she used this text to show that this person had sent her a text and to harass her after the fact, that my client had insisted. She goes on the stand, and I had produced in my binder, he had given me 125 screenshots where he'd been this person, an advisor to the family type of person, had been communicating with her on her behest since, for 5-6 months already. So she testifies, she has this one text, and the guy's just basically like, look, you don't want to go through with this. It's not good for your kids and whatnot. So she testifies that that's harassment. So that's what they have, and her attorney is. So what you have with exhibits, you can present them, you can talk about them, but they have to be entered in to the court, okay? So you can offer them as evidence, and then the court will take them in if they admit it. So he's going through this before lunch, he's going through all his documents, and he's saying this one, and I'm objecting, that's hearsay. And then her and her friend's text, I'm like, hearsay, and the judge is like, yeah, then that's coming in. And then he goes to this one here, and I go, it's admitted. I said, yeah, no objection. Now, it should have been objected to on hearsay grounds, just like all those other ones. But I wanted that text in, and I wanted it in for a few reasons. There's a penitent clergy, that's who the guy kind of was, clergy exception, that one of the parties can, for privilege, say, I don't want you using it, because they want you to be able to talk to your priest, your rabbi, your pastor, whomever. And this guy could have maybe fallen under that, but she was using this as some sort of harassment. And so I allowed this in. So later on, I'm going to impeach her testimony by bringing up all these other texts because she literally testified that this was out of the blue. It was unusual. And I have hundreds of texts showing it's completely not. And they're like, well, that's hearsay. You can't do that. And I'm like, well, then I'm just using it to impeach her. And they're like, well, it's privileged. And I'm like, well, you opened the door by already presenting evidence that you've already admitted as evidence. And the guy's like, well, that's hearsay. And I go, why? I didn't object to it. Well, we only did it for the state of mind. And I'm like, I didn't object to it. You didn't have to give a reason, an exception, because I didn't object to it. So now this goes in. The overall outline of this thing, they wanted to stipulate that we would, because I was going to bring the guy to testify, that they'll just stipulate to not even having this as an issue before the court. There you go. So anyway, we're sitting down there after lunch because we're going to come back from lunch, and the judge is we're going to do one last, I don't know, maybe we're going to have some testimony. We're closing statements, and then he's going to rule on it in a few days or so. So we're sitting there waiting for the judge to come out, and I can hear opposing counsel. Well, first of all, he says, hey, you know, when this is over, we're going to need to extend this restraining order until, you know, for whatever, and I don't have the right form. And so he's kind of saying, I could use this form. I said, no, it's the DV, you know, I know the form that you need. So I told him which one it was. And then he's talking to his client, and he's like, oh, and you know, we got a boat and might go out of the boat because we're going to go and celebrate tonight. And I'm just like, okay, maybe you won, maybe you didn't. Then the judge comes out and he's like, you know what? And now the courtroom is full. Okay. It's like my client, he's had a few friends that have been there the whole time. There's other ones we were thinking of calling for witnesses. So they never came in. They were in now. There's like maybe 4 or 5 of them. His whole side or my opposing party and counsel, their whole side is full. Okay. And it's full because he's got, it's him, his other attorney, client has some support staff and some friends. And then he has like 5, he had a paralegal, and then he has like 5 people from his office just chilling in there. And the judge is like, are these new people? And he's like, no, that's my office staff. They're here to celebrate. So then the judge goes, you know what? I started thinking over lunch. Well, first of all, we had to rule on one thing. He's like, the experts report. They wanted to have it entered now. The expert had got up there. I think I did an okay job against him on my cross-examination. But it was just a lot of, you know, foo-foo shit. She has PTSD. Okay. Well, you know, I had reasons for, anyway, there was a lot of good pushback. But then he had a report. He talked to her. He talked to her friends. He had, you know, the analysis in there, and they wanted to have this report entered in as evidence. And I'm like, absolutely not. That's hearsay. There's like triple hearsay. They're friends telling about hearing stuff from other people in that report. That's complete hearsay. And the opposing counsel, this is before lunch, he's like, oh, no, we've had this entered in as evidence in other cases here. And I'm like, well, okay, but it's not, and I'm going to fight it. And the judge is like, yeah. And so then he cites this case, the reason that it would be in, and then he goes, oh, that is an unpublished case. So anyway, over lunch, I didn't leave the courthouse. I had lunch there. I just sat there. My client went and ate. I sat there and I did a little bit of research, and I wrote my closing statement, closing statement. So I looked into this, and I'll just give you a little bit of analysis of this stuff. So hearsay is still a problem. Now there's multiple kinds of restraining orders. There's criminal restraining order. There's civil harassment restraining order. That's you and your neighbor. And then there's ones under the Domestic Violence Protection Act, the DVPA, which are universal, around the states. Most states have adopted this, I believe all of them. And the civil harassment restraining order does allow hearsay as evidence. So there is cases about bringing stuff in, and but the DVPA, that's very specific. That they haven't had anything that says you get to bring in the civil harassment restraining order statutes actually say that's fine. The DVPA says nothing about it. And the fact that it says nothing about it means you're just still open for rules of court, civil rules, and hearsay is still one of those unless you have an exception. Then I looked up about unpublished cases, and I found the rule of court for that, 8.1115, as it comes off the tongue there. You can't just cite, and the judges can't use unpublished cases for making rulings. So anyway, we go in there, the judge is like, I think I'm going to rule that we're going to bring this in. You guys want it. So I just flat out, I started saying exactly what it was. And when they end, the judge is like, yeah, I'm not going to admit this. And I knew things were good. So he's like, I've actually decided I'm going to make this decision right now. So there's a lot of things that need to be, kind of figured out. So I figured we should do it now. And I was like, oh, my client has not had custody since this thing went in, except for, well, he's had unsupervised actually, just for a few hours every weekend. And I'm like, I bet that means he needs to change. So far I'm feeling good. And he starts out and he just basically says, she's not believable, to that same point. The first thing he said before this, he's like, Mr. Yonke, you had, in your trial brief, you had mentioned, the other party didn't do a trial brief, by the way. And he obviously read it at the lunchtime. He said, you mentioned you wanted attorney's fees. How do you get attorney's fees for a case like this? I said, well, if you look at the code, and I'd cited it in there, it's a prevailing party in domestic violence restraining orders can get attorney's fees. And he's like, well, what? And he starts to look at it. And I said, well, it's got to be frivolous. And I believe the way that this was, the allegations and how we disprove them shows that it's frivolous. He's like, oh, okay. So he didn't give us attorney's fees, but I felt then it was looking good. And then he starts walking through and yeah, we won. So denied the restraining order. It was a big deal. I mean, I had put so much work into prep for this case. Like I said, a lot of stress from friends and family to help this guy. And I totally believed him. The evidence played out that it was the case. And then the issue with opposing counsel, by the way, he drives a cyber truck with a personalized license plate talking about suing. It was the most fantastic thing. You can't set that up any better. So I had an amazing, I was dead tired after that, but that is pretty amazing. And by the way, do I feel this way about all my clients? Yes, you definitely want to take care of all your clients like this. I will say, like even the little trial thing that I had this morning, that client always has all the documents. Now, sometimes we got super lucky with having this judge who was tremendous. I think he comported himself. He was in control of everything. He allowed us to do our thing. And he even said after the fact, he's like, I was telling the clerk, it's nice to have attorneys that show up that know about the evidence code. And I was like, oh yeah, that's, and then, I don't mean to toot my horn here because honestly, you're going to think this is stupid. So do you pray for stuff like this? Yeah, I pray for, a guidance that I'm going to be doing the right thing. And then you put yourself in preparation. And I got to say, I'm not going to show you this, but this is what my client sent me Saturday morning. He said, good morning, Tyler. Your cross-examination and closing argument was compelling. Excellent. You make me want to change careers and pursue law. You were simply brilliant. Thank you and remain blessed. And I only say this because I don't think at all it was brilliant. I was doing what I could do, the best I could do, putting myself in position. But I got to say, and just like this morning's client and this guy, they did what they did to put themselves, and by the way, when the judge is done, he's like, we need to change custody or do custody orders. So we have to go back to court for that. But he immediately gave my client, like weekends. So huge win for a father because this affects a lot of stuff. And they could have, the offer we gave would have actually advantaged them in multiple ways that they did not take, that they could have because of the cockiness, I think, on their side. Not even looking at the exhibits that we had presented, months ago and stuff. And we had an earlier issue in this case where we filed an ex parte order. It's an emergency order to change some things because they just weren't following the rule. And the judge was so frustrated, she denied the ex parte as an emergency, but she totally changed custody stuff in there from like supervised to unsupervised, which is huge. And a restraining order at that point, okay, before you determined, because there's presumptions about you shouldn't have custody if there's a possibility of findings of domestic violence. So, and even then, the parties testifying that we lost this, this restraining or this emergency, and it's like you're not understanding what happened in this context here. You got to start to understand and to read things out to figure out what's going on. And my client, once again, I would just want to say, super prepared. I was like, every time I needed something, he gave me documents. And this is kind of the point of telling this tale, one, to brag a little bit, but it's not me. It's just me getting in prepared and doing a lot of the work that, a lot of people could do. You do have to know what you're doing, of course. So I feel like, that's part of it. I'm not brilliant. I just really try to go with my gut on the, and I've had, I won't get into that. but with that, you know, for men especially, you know, guys always complain about stuff, but they're not, and it's not their fault. This guy is just hyper organized too. And men don't always prep for litigation. So the fact that, as an example, this never would have been the case if he hadn't have saved all his text messages. Now, also what it blows me away that a counsel would present a text message like they were doing multiple times without saying, I need all the context. I want all your text messages up until this conversation is about something else, and all the ones through this until it's about something else, right? So you get all that context in there, and you could present that to the court so that it's all in context. And if he, and like I said, we had day one through the end of, you know, like a month and a half, and it saved him because there were certain comments in there by the opposing party that she would continue. It did not make sense, right? Did not make sense for the allegations, which we won't go into. So, okay, let's, did he wonder what a ute was? No, he did not, Iron Face. Halbeson says, sounds like that lawyer makes most of his Cybertruck money off settlements. I don't know what he does. My cousin Vinny too. I missed it. How did opposing counsel get unpublished opinion? Chat GPT. Well, I could not find that. That's why I decided, he just said it was an unpublished decision. I could not find the reference that he did. The judge actually said he couldn't find it as well. So yeah, Alex Baldwin shot me and dies. Okay, last words exception. There is a lot. By the way, thank you. The only time I did come up with a case, I was chat GPTing at lunch, by the way. I was doing everything I could to try to find something. And I did find a case about using kind of exactly what you're saying. So you do have a right for a confrontation clause, you know, and it was a criminal case, so it didn't play into ours. And I actually looked it up, and it's where you made the one party, the defendant in this case, made a witness unavailable. What does that mean? He might have put a slug in them. He made them unavailable, and therefore you can use your hearsay because, but for their conduct, you know, this person would have been able to come and testify. So, but that wasn't the situation that we had here. It was just an expert that wasn't much. I mean, like as an example, this is what it was. So there's times of abuse that she's alleging up to a certain date. Then after the fact, she goes to an expert and he interviews her, and he's like, lo and behold, she was abused. She has PTSD from only that abuse that she self-reported. We didn't talk to anybody else. We don't know if she's telling the truth. It's only, but we have these tests that show, and I'm like a lie detector. No. Anyway, so it's all that kind of stuff. It didn't make sense. The judge wasn't really buying it, and coercive control, none of that came out. So it was a fantastic trial. I was dead. I came home Friday. I was pretty tired. I said, honey, let's go out. So we went out, and we did celebrate, right? So had some drinks, then crashed. And I was going to do a show over the weekend, but we didn't get to it. And then I got stuck down a rabbit hole. I don't know what was, I was strolling through stuff. You people tell me if you've ever heard of this guy, Ren, Hi Ren, the song specifically. I went down the rabbit hole listening to this dude, and he's phenomenal. And you know, my wife, she's a big fan of Eminem, and I've always said he's a talentless hack. You can agree or disagree. I found the guy that I think is not the talentless hack. I mean, because one, he could sing, and he can rap, he can play guitar, he can play the piano, and he writes dope shit. So it's kind of amazing. It reminded me, I don't know how, you know, correlating this is. It reminded me of when, for me, when grunge music came out. One, I like grunge music itself, but I liked, you know, sure, they all died of heroin overdoses, but it came out of the, you know, the hair metal, right? And which, fine, there's some good hair metal bands out there, but they were so gay. All the makeup, the hair, the tight pants. And then you suddenly just had some dude in jeans and a flannel. And I'm like, okay, so he's not trying to be gay. He's a druggie. Okay. Have the wherewithal to dress up. And then, you know, then we had Alice in Chains, 9 Inch Nails, the soundtrack to Singles. I don't know. That got pretty good. And it reminded me of that, where I'm like, oh, I don't have to listen to Kendrick Lamar and Eminem rap. I can listen to someone that's just different. Just different. I don't know. No one's commented about that. So maybe I should just, maybe I should let that one go completely. Okay, should we talk about this stuff though? I don't know. So I found a tweet here that I thought was very interesting last week. Now, Robert Barnes has me blocked, but however, could we see it there? No, we're gonna have to fix this. Sorry, folks. Oops. Oh boy. So Robert Barnes is defending RFK Jr. in a defamation suit. So he comes up here and he says, "We won today in court on behalf of Robert Kennedy Jr. against libels like the kind currently used against him. The court noted that," okay, so first of all, I have a difficult time saying I won today in court. Now, did I tell my wife that today? Yeah, there's 2 hearings I had and we won those, I guess. But he's making it sound like, because then everyone here commenting off of this, it makes it sound like they just won the libel suit, okay? The court note, but then this is the part where I'm like, because here, let me go here. So this was Robert just won a lawsuit. This is how it's being reported. Robert Barnes just won a lawsuit on behalf of RFK Jr. Now, lawsuit to me means the judgment, okay? It's not like a motion to in limine, or well, that would be for the trial, but some stupid motion along the way, okay? Right. Or, maybe the opposing party is filed a motion to dismiss and you kept it from being dismissed. So temporary win, the little battle, but not the war. Now, this guy says he just won a lawsuit on behalf of RFK Jr. against Daily Kos, writer for libel. David Vickery falsely accused Kennedy of contributing to Samoa's 2019 measles outbreak, causing 200,000 deaths by lying about vaccines and much more. Now, we heard about that in the confirmation hearings. So completely true, because those people were, spreading that stuff as well. I'm assuming it's false. Barnes, the court noted, then repeatedly that repeating those libels, and so I'm reading this. So let me just back up a bit. This started from, oh shit. Oh, I just lost it. I'm gonna have to go back and find out where it was. We'll go back to this one. Because it was from Kinsella saying, hey, why are libertarians, are you against defamation? Yeah, I am. It's all bullshit. So anyway, this guy says he won, Barnes. And so, I saw this and then I go, oh, he's quoting Barnes here. And Barnes says, the court noted that repeating these libels after Kennedy has already sued puts everyone on notice that it is libel with actual malice. Okay, so I'm like, wait, what? He won the lawsuit. Who fucking cares? It would be another lawsuit, right? It would be an additional lawsuit. It's not even protected by res judicata because it's a different issue. Well, it's a different event, right? So I'm like, what are you talking about? So then I go to Barnes's thing, and it does. Motherfucker, he does. He did say that. Well, I'm sorry. Gosh, dang it. Okay, here we go. There we go. There we go. Okay, so then Barnes says this, and he says that thing, would the libelers pay heed? Okay, so then I wanted to look at this. What is going on? Did he win a lawsuit? Because if he won a lawsuit, then the court doesn't care. Matter of fact, they've already would have determined if it was actual malice. We've talked about that with defamation suits before, but I'm like, is this what I'm getting here? I think Robert Barnes is a little shifty with shit, right? Hey, Robert Barnes won a lawsuit for Kennedy. Did he? Did he win a lawsuit? Well, let's look further. So here's the actual case in court. He won a motion to dismiss the case, okay? So if you look here, though, this case was initially first filed by Barnes in federal court in New Hampshire. In New Hampshire in 2018 or 19, I believe, I'm sorry, not 2018, it was 2023, sorry. And it was dismissed, summarily dismissed because a wrong venue, multiple other factors. Barnes didn't file shit in time, so it was kicked out of court. And then so now they filed it in it's Connecticut. Is that where it's at now? Oh no, I don't know. Some other Maine. Now it's in Maine. Cumberland. tried to find this. I could not find this lawsuit specifically. Some people would put some stuff over here. So here's the actual affidavit of Robert Kennedy Jr. in opposition to defendant's motion to dismiss. So they didn't get it kicked out. It's a live case now, but he hasn't won it yet. So all you're, I mean, like maybe Barnes is into the point now, and then and then you have text or stupid shit underneath it, like like Josie, but proving malice. Here, let's go here. Proving malice can be difficult for a public figure and the media. You are a great lawyer. He didn't prove malice. He proved that this case might be able to go to court, or continue. That they didn't kick it out on a motion to dismiss. And Josie's no dummy, but that's exactly the kind of stuff, because he's disingenuous, I believe, on a lot of this stuff. Okay, what else do we got here? Hubbleson, how do you get word to RFK Jr. to fire Barnes? Should I put a note in a bear card? He'll find out. He'll find out when this one gets, when he loses this one as well. By the way, Barnes is not the head attorney because I don't think he's registered in Maine. So the other attorney is the main one there, and then he comes to Hoc Provice or something like that, Vice, that he gets to participate in the case there as well. Robert Barnes has a habit of LME, legalistic premature ejaculation. Early on, he declared in poorly aged declaration, Rekieta has already won. Yeah, well, we know that. How you doing, Max? Big win today in court, pizza day. Okay, you Iron Face or me or Barnes or who? Beer bonging raw milk. Should we maybe we should look at let's go here again. Let's go in here. Let's see what people said on Josie thing. Nearest time V. Sullivan, I agree. Okay, well let's just say in here. Why can't you? Author blocked you. Robert Barnes blocked me, so I can't even comment on this kind of stuff. Oh, you motherfucker. He's the best lawyer. These people are sick. Let's do this. Let's quote this one up here. Malice has not been proved. This was just a motion to dismiss that they won. Previously dismissed in federal court. All right. Lawsuit still to be determined. There we go. There you go. What is he? He's not even going to see it because the motherfucker. I think I blocked him too. So there we go. There you go. And look, this is the kind of shit that gets me worked up in a way, which is I like this. There's stuff out there, and you just see just a tad bit that piques your interest, and you go, now Robert Barnes may very well be a better attorney than me. Completely fine. But I'm not out there lying about my shit either, right? So that's the problem you have. I did find a case someone wrote something. Is it this one? It is. Let's read through this. I didn't realize I had this, and I'm gonna have to bring this down though a little bit. Whoops. This is an article someone wrote exactly talking about what a POS Robert Barnes is. So maybe we could walk through this one. That might have to do. Okay, let's go from there. In August 2020, when Robert F. Kennedy Jr. was in only a danger to the human race. Okay, by the way, this person, whoever wrote this, absolutely hates RFK Jr. So you can have, and this is what I don't want to do, and this is the problem I think Barnes gets, which is he's on one side of a political spectrum, which means he can't take other views, right? Just like he's friends with Rekieta, but so was Kurt, so was Nate, so was Sean, and so were a bunch of these people. But they saw that it was just utterly, almost despicable to try to fall in line and lie about the situation, which Barnes and Viva Frei were more willing and capable of doing. So, that's kind of, so this is an article that absolutely despises the right, doesn't like Robert Barnes because of his politics, doesn't like RFK Jr. now because of politics. But does it mean that everything in there, we'll dismiss some of it? But I'm interested in some facts and stuff in here. So we'll actually do that. Okay. Deranged enter vaccination hysteria. An anonymous blogger under the pen name Down East Dem penned a post at the Daily Kos highlighting the political scion's appearance at a rally in Berlin to protest Germany's coronavirus lockdowns. Perfect. Although the country's public health measures had largely been repealed, Kennedy accused of Angela Merkel of totalitarianism while ranting about Bill Gates and the evils of 5G networks. Now, I don't know if he ranted about all that shit, but I will tell you this. Just because she had relinquished some of the totalitarianism doesn't mean that she still wasn't. Okay, and plus she's German. Now, you defending the Germans? Come on now, that seems not respectable. 5G networks. Where did we go here? Okay, there we go. Make sure you guys can see that. The post was just 155 words long, and its central claim that Kennedy spoke at a rally, quote, including a large contingent of far-right groups and members identifying with the U.S.-based right-wing conspiracy movement, QAnon, unquote, was confirmed by multiple outlets, including CNN, NBC, and The Guardian. This made Kennedy so mad that he did nothing about it for almost 3 years until 2023 when he decided it would be fun to pretend to run for president of the United States as a Democrat. Maybe he was too busy defending free speech by suing Facebook, FDA, Senator Elizabeth Warren. I agreed with all those lawsuits, by the way. Those were about censoring him on the internet and YouTube specifically. That one doesn't say about YouTube, but I'm pretty sure he sued Google as well for that. Unlike other major political parties, palling around with neo-Nazis is generally viewed as a net negative on the blue team. So, to prove to the world that he's definitely not the kind of guy who would appear alongside right-wing extremists, Kennedy hired right-wing extremist and former attorney for Alex Jones, Robert Bobby Barnes. Now, there's a lot of stuff here, and I bet if we were to click on, let's click on this and see what's the corruption of the FBI. Okay, I don't want to listen to him talk to, but that's not proof that he's a right-wing extremist, but he is an attorney for Alex Jones. Barnes previously represented InfoWars in a Sandy Hook litigation and was one of the 3 lawyers singled out by corporate representative Brittany Paz, who testified that the company was considering suing some of its prior counsel. Okay, let's take a look at that. Alex Jones is turning on his own lawyers in the Sandy Hook case. Okay. InfoWars conspiracy theorist could soon sue his own lawyers as Jones and his company scramble to blame someone else for their legal failures and lawsuits over their lives about Sandy Hook. Jones and InfoWars have consistently lost in courtroom across the country to families of the school shooting victims, blah, blah, blah. Let's get, where does it talk about? But the public shamings haven't stepped, okay, namely, they're frequently rotating members of their legal team. In a February deposition obtained by a Daily Beast representative of InfoWars parent company said the conspiracy theory outlet was discussing the idea of suing Jones' former lawyers for legal malpractice. I did have concerns on behalf of the company regarding the company's prior representation. Yes, Brittany Paz, a lawyer acting as a representative of the company, said the possibility that Jones will sue his own lawyers struck Mark Bankston, an attorney representing Sandy Hook families in Texas, as odd. It's unusual to see a defendant turn on his attorneys in the midst of litigation, but it certainly fits the pattern of Mr. Jones blaming everyone else for his problems, Bankston told the Daily Beast in an email. Bankston is also representing the estate of a man InfoWars falsely accused of being Parkland. Okay, we don't care about that. There we go. Paz doesn't say in her deposition which of their former attorneys InfoWars might sue, but she singled out 3 lawyers, Mark Randazza, Brad Reeves, and Robert Barnes, for special criticism. Paz also accused some of InfoWars lawyers of badly botching document discovery in the case, an issue that has plagued InfoWars and prompted accusations from plaintiffs' lawyers that Jones' lawyers were deliberately sabotaging the process. I'm not sure what documents were produced in which cases, Paz said, and that's a problem with the organization amongst the attorneys. Yes. By the way, I mean, I have a little operation, and discovery can be a big problem, and you've got to be highly organized for it, even with this little stuff. So I imagine if you're doing it and it's all this, massive discovery, you almost just have a law firm one section just designated for all of this, so that it's all very, very organized. And we've seen that with some big trials, the discovery that's outlandish, and, the attorneys seem to be getting it right. But Barnes, they defaulted on him because that's one remedy for not complying with discovery is we're going to default on you. Now, 2 times, and Barnes went in there and complained that it's bad judges. Well, I don't know if it was bad judges. You would think they would appeal these and get them overturned if there wasn't a basis for it, right? That would totally happen, because what the courts don't like, even if you push it all the way up, is precedents to be set where it's just a judge playing around. And so if your discovery is not going on and you've got a motion to compel and you have a full trial on that issue, you're able to present everything that you've done, the judge is going to, but evidently it didn't happen. Now, I don't know all the details, but let's see if we can fix this thing. I'm sorry. I didn't realize I was cutting off part of it. There you go. There we go. Okay. Both Rendaza and Barnes have become celebrity free speech attorneys. Actually not, because I think I complained to Barnes about some of his ridiculous comments about the Middle East, and he's not for free speech over there. Just letting you know that. Or he's probably not even for free speech in the U.S. concerning that as well. Told them, what did they say? Both Rendaza have become free speech among conservatives for their work on behalf of InfoWars and other right-wing clients. Rendaza once pleaded guilty to ethical violations in the Nevada bar investigation to whether he cut a side deal with another client's legal flow. Jesus Christ, how do you continue as an attorney? In a statement, Rendaza told the Daily Beast, said the other utterly terrible, quote, lawyers who have worked for InfoWars are trying to distract from their own mistakes. Interesting. The revolving cast of lawyers at InfoWars has included some outstanding lawyers who are confident in their own abilities, Rendaza wrote. It has also included some utterly terrible lawyers who have had some of the dumbest moves I've ever seen. Those in the latter camp seem to be interested in deflecting attention from their incompetence on the competent lawyers who compete with them. Reeves, anyway, is there any more about Barnes in here? Okay. Barnes and InfoWars did not respond to requests for comment, but it is unclear how serious the rift between Jones and Barnes actually is. The lawyer appearing on an InfoWars broadcast with it a few weeks ago. Okay, let's get back to this. Now I gotta readjust this stupid thing again. One day we'll make this all work, people. Okay, but what I wanted to do here is, let's look at this chat here. Holy moly, it's national holiday in Japan, so I clicked into this chat which is super terrifically chill and informative. So why only 11, 13 subs, Office of Tyler Rock? Yeah, exactly. Come on, Max. Thanks for the help. Barnes had pizza day, I assume. Yeah. When I first heard Barnes' war stories, where he names and discusses client cases with names, etc., you assume by the way he tells it that the client won the case. Barnes is the opposite man. Yeah, that's true. Daily Cost, CNN, NBC, The Guardian, unblemished bastions of impartial and objective journal. Yeah, totally not. Well, the jury pool seemed tainted, in my opinion, but I don't know about the judges. Could be completely true. The problem is Ian Face, Ion Face, I don't know, whatever. INF Ace. The problem is the jury did not hear, and they did get a select something. The jury didn't decide that this was a default judgment. The jury only heard stuff on damages. So, the judge is the one, the gatekeeper, and the judge does suck, right? We all know that. I'm not dismissing that, but you're putting yourself in a position by not following all the rules where you're getting caught out. So, if, as an example, if we had, in the case that I was just talking about, my own one, where there were deadlines, which there were for filing a witness list, I was up on that. If I hadn't done that, and they're like, maybe you don't get to have your witnesses, and you're up to the whim of the court. And the court can be harsh, or it can be equitable and some stuff. So, my point on the whole Barnes or Jones and the default is, it got to a default. The trial was only over remedies, over damages. So we didn't really, in both cases. So we didn't really get to hear that. Oh yeah. Okay, let's keep going on with this. right-wing extremists, like I said, but we did just see, there's an article about some of that. Barnes previously represented InfoWars as Sandy Hook and was one of the 3 lawyers singled out by corporate representative Brittany Paz, okay, we just said, who testified, when it came time to list actual malpractice claims that InfoWars intends to survive its bankruptcy and reorganization. However, the company listed just one of those lawyers, Bobby Barnes. In its proposed plan for reorganization, InfoWars expressly reserved all causes of action arising out of, quote, professional malpractice claims against Robert Barnes and Barnes Law LLP. Oh, interesting. Just to be clear, InfoWars Texas attorney Adino Reno mistakenly handed Alex Jones's cell phone to opposing counsel and separately got sanctioned nearly $100,000 for making false statements, acting in bad faith. See, this is the stuff. This is part of it that went into this whole deal here. So, when we're talking about a lot of this, bad behavior or the judge made this, well, you didn't help the situation. Help your client, for Pete's sake. Falsely acting bad faith, significantly interfering with the court's legitimate exercise and court functions. Now, Barnes is going to say, no, Tyler, that's not what happened. When he gave him the phone, wait, I don't have an excuse for that. But no, it's the judge. And it could be right. But then we've seen how he'd act in other things. And significantly interfering with the court's legitimate exercise and core functions. Meanwhile, in Connecticut, Alex Jones replaced Barnes with stand-up lawyer Norm Pattis, who promptly steered Jones into a $1.4 billion loss and got himself sanctioned for misconduct along the way. Apparently, that's par for the course. No, the only lawyer Alex Jones thinks might be incompetent is Bobby Barnes. So, of course, Kennedy hired him. Could be. I don't know. I don't know all the details. I've tried to look into some of these filings. It's too much there. On Kennedy's behalf, Barnes threatened to sue Daily Kos and the blog. Now, this person isn't really saying what the cause of. They're talking about that right-wing extremist thing over in. You're not going to win a lawsuit on that. This had to do with the Samoa. Okay, saying that he was responsible for deaths over there by what he said. That's not at all what this person here is. So they're misstating facts as well. Just understand that, right? Now, I'm reading this because it's damaging to Barnes, so it's fun, right? But you also realize it might all be shit, except for we know some of the underlying issues, right? We know that there was attorney malpractice. We know that there was default judgments in 2 cases against Jones for not turning over discovery, according to the, that's 2 judges making the same determination in 2 different cases all the way across the country. Well, one's in Texas and one's up there in New England. Okay. All right, Barnes. On Kennedy's behalf, Barnes threatened to sue Daily Kos. To their credit, blogger and Daily refused to, after which Kennedy did actually file a lawsuit claiming that his speech at a, quote, protest for peace and freedom could not possibly have been extremist because there were Hare Krishna supporters during the dancing in the audience. Oh, geez. But a funny thing happened on the way to the courthouse. Kennedy's case wasn't filed in New York, and it wasn't filed in California, where Kennedy keeps a second home in it either. In fact, it wasn't filed in federal court at all. It was filed in state court, I think New Hampshire, and then the Daily Kos guy removed it to federal court under diversity claims. And by the diversity doesn't mean like there's a black person. So anyway, we'll get to that. So they didn't know who he was, so they filed it exactly 2 years and 364 days after Down East Dem. That's it. Published his original story. Kennedy dodged a few bears, marched into Rockingham County Courts in Brentwood, New Hampshire, and sued the blogger for libel. And those 2 things are not coincidence, because even if he had been defamed, and this person said he wasn't, the statute of limitations for defamation in any of the jurisdictions where Kennedy could have plausibly have sued is 1 or 2 years. New Hampshire is one of the few states where 3-year statute of limitations on defamation, and so it is often a destination for defamation tourists whose claims are time barred in their home jurisdiction. Rudy Giuliani did the same trick, blah, blah, blah. Kennedy, who represented a state court by immigration lawyer Jason Sullivan, claimed that the blogger had targeted him in New Hampshire, seeking to... Okay, I'm not really caring about that. Let's get to... Okay, suing in New Hampshire wouldn't have necessarily made the case timely in any event. Since choice of law does not depend on where the case is filed, more to the point, that's not remotely how personal jurisdiction goes, even in New Hampshire. So Vic Ray immediately removed the case to federal court and filed a motion to dismiss for lack of personal jurisdiction. And that Stephen McAuliffe, they actually dismissed it. Okay. Fundamentally, then, counsel's late filing was caused by, there was some other late filing shit there. Yeah. So Barnes was supposed to file some additional stuff that he didn't do, and it was late. The irrespective of the time zone bit has to do with the fact that Barnes lives in California, where the district court is located in New Hampshire. When Barnes filed at approximately 2:30 a.m. Eastern Standard Time on the 22nd, and it was still the 21st for a few more minutes on the West Coast where he lives. Not that it matters. Local Rule 6.1 makes it clear the deadline is at midnight time, not midnight time zone where your lawyer happens to be in. Fundamentally, then, counsel's late filing was caused by his acknowledged lack of familiarity with both the federal rules of civil procedure and the court's local rules and administrative procedures governing the timing of the court filings. Judge McAuliffe concluded granting Vic Ray's motion to strike the appeal. Ouch. As much as it pains me to say, it seems like Alice Jones is right. So the bad news for RFK Jr., thin-skinned, anyway, this person. Now, they've refiled. I haven't looked at all the pleadings for that. I do have one of them here. We could always, I'm not going to go through the complaint. But maybe as that thing moves along, we'll get there. We'll get there, maybe, if I could find any more. Okay. Is there any more of this chat shit we want to talk about? Heat on face. Maybe InfoWars can apply a $1.4 billion government grant. Didn't mean to send that. Oh, Jose. Yes, you did. You meant to send it. Yes, you did. All right. I think we're about oot on this. This one might not get monetized because I'm using some other music. We'll save that. Maybe I'll try to play it for the Tower Game intro the next few days. Okay, so that's what I have. Wednesday, Tower Gang. If you guys are interested in that degenerate show, check out Jose's show. No Way Jose, his morning dump. I've been enjoying that almost every morning. I tune in on the way to work. So thank you for Jose for doing that. If you guys have any other suggestions for shows, please let me know. Once again, we can't hear that though. I don't know what you're talking about. This is definitely coming through. So thanks for hanging with me today. Let me talk about the trial. Once again, I'm not brilliant. I had a good client, just doing what I can. I pray that I get inspiration to do the right things, and I think I was helped out. This is what really comes through when times like this happen, and I had this. Are you blasting grunge music? I'd be into that. Let me see if I have any grunge music here. I usually have something, but you get stricken for this if you play this. This will definitely get me stricken. I don't know. Is 9 Inch Nails, are they grunge? I have some of that. Okay, so anyway, take care out there, people. Do your thing. Be the best. Blah, blah, blah. Like and subscribe. We need more subs for this show. We'll come back on Friday. I don't have court the rest of this week. I will prepare something. We will be here on Friday. Love you all. Bye.
Things are going to start happening to me now.
I think Tyler is amazing.
And I'm a fan of this show. I've watched several episodes.
Thank you, Tyler. Thank you, Tyler. You stink, Tyler.
Never promise crazy a baby.
Oh, I like that. That's a cool idea.
Are either of you homosexuals?
I go both ways. What do you think?
You mean like flaming or?
No, we're not homosexual, but we are willing to learn.
But I do wonder, for others, in other cases, whether libertarianism today is just an excuse for many on the right to act selfishly.
Look at me. And then some fat asses in Washington started having opinions. The Olympic Committee started having opinions. You bitch, I know you. You started writing your opinions.
And it just makes me wonder, you're dead, bitch. Why are you doing this to this poor guy?
I don't care. I'm a libertarian. What I'm getting is...
Did you vote for Joe Jorgensen or Trump?
Who?
Joe Jorgensen. That was the perfect answer. Thank you.